I'm pleased to be able to talk about our recent victory in Subramania versus USCIS. This case was filed as a class action on behalf of our client and 75,000 other applicants for employment authorization, whose applications were approved, but the EADs were never created. We filed suit to force USCIS to produce the EADs so that our client and the rest of the class would be able to present those cards to employers and either return to work or begin working, as the case may be. This case started like many of our cases, where some glitch happens in the process. Ranjitha Subramania applied for an extension of her H-4 status and the EAD with her husband's H-1. And all of those applications were approved on April 7th of this year, both the H-1 for her husband, the H-4 extension, and the EAD. May 1st came and went, and she still hadn't received the EAD, and she kept asking, and we kept saying, well, it comes, a few days, but it didn't come. So we started making inquiries. First, we did an e-inquiry, and Ranjitha was calling the contact center on a pretty regular basis. And we would get responses that we'll get back to you in 30 days. It's under review. We'll get back to you in 60 days. A lot of unsatisfactory answers. So we went the congressional route, and the senator's office didn't get anything better. And so we then decided to file a lawsuit. We got to the end of July, or the beginning of July, I'm sorry, and she had to stop working. So we prepared a lawsuit and sent it to the assistant U.S. attorney. Usually that's enough to resolve it. Strangely, after we sent it to the U.S. attorney's office, we got a reapproval. In many years of practicing immigration law, I've never seen a reapproval of any application, but I took it to mean this time that the card was going to be produced, but it wasn't. And at that point, we saw the column in the Washington Post that said that the USCIS had stopped producing these cards and that there was a backlog of 75,000 people waiting for EADs. So at that point, we amended our complaint and filed it as a class action. We also asked for a temporary restraining order and a mandatory injunction because we wanted to get it before the judge right away. The judge held a hearing within a week of our filing the complaint on the temporary restraining order. It took evidence. Our client testified. We had a few other clients from across the country that had been waiting for an EAD, very sympathetic cases. And they testified. Somebody from the USCIS testified as to what the problems were. And the judge ordered that the temporary restraining order should be granted. He did not identify very specifically what that meant. And after the order was entered, we realized that it was impossible for USCIS to produce 75,000 cards that day. I mean, that just wasn't going to happen as a practical matter. So we entered, they approached us actually to enter into negotiations. And we set up a timetable, a very strict timetable that will end in a couple of weeks, having produced all of the cards. But the critical point was that in the meantime, we convinced them to post a notice on USCIS.gov that allowed the approval notice to serve as a List C document for an I-9. And that gave the 75,000 people immediate work authorization that they could take to an employer and begin work the next day. We would like to make sure that USCIS produces the cards as promised. The consent decree is a court order, and if they fail to comply with the terms, we can ask the court to enforce the decree. A copy of the court order is available on AILA.org, together with resources if you have a client whose card has not been produced as promised by this decree. If that's the case, we would like to know. Please send us an email at 765approvals@porterwright.com, and we'll be able to follow up and make sure and monitor that USCIS complies with this court order.
you.